Judgment in the matter of J. Chandler against the State.
This appeal by J. Chandler, who was convicted of murder, is a challenge to the constitutionality of the mandatory death sentence for murder in Trinidad and Tobago. Mr. Chandler will not face the death penalty as his sentence has been commuted to life imprisonment, but his appeal allows the Judicial Committee of the Privy Council to reconsider its earlier judgment in the case of Matthew and State of Trinidad and Tobago in 2004, which upheld the mandatory death penalty as constitutional. It is to be emphasized that the appeal is not concerned with the legality of the death penalty. The appellant accepts that the death penalty is not forbidden by the Constitution of Trinidad and Tobago. The appellant's challenge is to the legality of a mandatory death penalty, which prevents a judge on sentencing a person for murder from taking into account the circumstances of the murder and the degree of culpability of the convicted person. It is not in dispute that the mandatory nature of the death sentence for murder is to be regarded as a cruel and unusual punishment, because the culpability of a person convicted of the crime of murder may vary enormously. The Constitution of Trinidad and Tobago, which was adopted 14 years after the state obtained its independence, and the Constitution was in 1976, prohibits the imposition of cruel and unusual punishments. Parliament is therefore not able to create a mandatory death sentence by legislation enacted after the Constitution was adopted. But the 1976 Constitution, like its predecessor in 1962, also has a savings clause in Section 6, which provides that nothing in the human rights provisions of the Constitution, which are Sections 4 and 5, and which include a prohibition against the imposition of a cruel and unusual punishment, shall invalidate an existing law. An existing law is defined as a law which had effect as part of the law of Trinidad and Tobago immediately before the commencement of the Constitution. The question which the board considered in Matthew was whether that savings clause protected the mandatory death penalty from constitutional challenge. It is a matter on which the board has ruled on several occasions. The board in Matthew, and in an appeal on the same issue from Barbados, Boyce and the Queen, comprised an enlarged panel of 9 judges in order to give a definitive ruling on the subject. By a majority, the board decided that the mandatory death penalty was not unconstitutional, as it was imposed by a statute that predated the adoption of the Constitution, namely the Offences against the Person Act 1925, and it was therefore protected by the Savings Clause. Several Caribbean states have, over time, replaced the board as their final court of appeal and have adopted the jurisdiction of the Caribbean Court of Justice, which I will refer to as the CCJ. Recently, the CCJ has developed its own jurisprudence on the effect of a savings clause in a constitution. It has held that the savings clause operates only after a statutory provision which instructs the court to interpret laws so as to modify them to make them conform with the Constitution had been given effect. Thus, a provision in an existing law, it is said, should be read down to comply with the Constitution, and the savings clause should have effect only where it is impossible to modify the legal rule to make it comply with the Constitution. This is an argument which the majority of the board rejected in their judgments in Matthew and Boyce, although it was favoured by the minority in those appeals. Because the CCJ had departed from the reasoning of the board in 2 appeals in 2018, namely Nervais, an appeal from Barbados, and McEwen, an appeal from Guyana, the board gave Mr. Chandler permission to appeal so that the board could review its jurisprudence and take account of the different approach of the CCJ. In a unanimous judgment, the board, which again comprises an enlarged panel of 9 judges, dismisses the appeal because it is not persuaded that it should depart from its ruling in Matthew. The board in its judgment explains that in Matthew and Boyce, a panel of 9 judges was created to give a definitive ruling in the face of judicial disagreement. The principle of legal certainty requires that there be very strong reasons before a board will depart from such a ruling. The principle of stare decisis, or standing by what has been decided, requires that the board be satisfied that the earlier decision was wrong and that it lacked a satisfactory foundation. In the judgment, the board explains the law on stare decisis. The board also explains that there are several reasons why the decision in Matthew should not be overruled. First, it is important to note that the interpretation of the Savings Clause affects not only the mandatory death penalty, but all other existing laws which had legal effect before the Constitution was adopted. The interpretation for which the appellant argues would alter the basis on which the government and people of Trinidad and Tobago have conducted their affairs since 1962 and would introduce uncertainty into the law. Secondly, the board has consistently adopted the approach to the interpretation of the savings clauses which it upheld in Matthew. Thirdly, the board recognises the right of the CCJ to develop its own jurisprudence, but the board explains why the CCJ's judgment in Nervais and McEwen can be distinguished from the decision in Matthew because of the differing constitutional provisions and factual circumstances of those cases. The board is not persuaded by the reasoning in the CCJ's judgments that Matthew was wrongly decided or that that decision took the law in a wrong direction. The board addresses 2 other arguments which the appellant advances. It rejects the argument that the mandatory death penalty is contrary to the doctrine of the separation of powers. The separation of powers is found in the Constitution of Trinidad and Tobago and is not a freestanding, legally enforceable principle that exists independently of and above a constitution. There is nothing contrary to the separation of powers for the legislature in Trinidad and Tobago to prescribe by legislation a penalty to be imposed on all persons for a particular offence. Secondly, the board also rejects the argument, which was not aired in the lower courts, that a mandatory death penalty is contrary to Section 1 of the Constitution, which declares that Trinidad and Tobago is a sovereign democratic state. The appellant argues that this provision gives rise by implication to a legal requirement that a punishment should not be arbitrary but should fit the crime. The board hesitates to address the argument without having the views of the local courts, but in any event, the board does not think that the argument adds anything to the separation of powers arguments, which it has considered and rejects. The board concludes by observing that the 1976 Constitution has allocated to Parliament, as the democratic organ of government, the task of updating and reforming the law, including the existing laws that are protected by the Constitution. It is striking that the mandatory death penalty has remained in place when it is now recognised as a cruel and unusual punishment. But under the Constitution of Trinidad and Tobago, such laws continue to exist only so long as Parliament chooses to retain them.
Judgment in the matter of Nervais Boodram against the Attorney General of Trinidad and Tobago.
This judgment will be explained by Lord Lloyd-Jones.
The principal issue in this appeal from the Court of Appeal of Trinidad and Tobago is whether the High Court, when commuting a sentence of death, can lawfully impose a sentence other than life imprisonment. Section 4 of the Trinidad and Tobago Offences against the Person Act provides that every person convicted of murder shall suffer death. The judgment of the Privy Council in Chandler and the State has been handed down this morning by Lord Hodge. In that case, the Board confirmed that the mandatory death sentence for murder is lawful under the Constitution of Trinidad and Tobago. Although the imposition of the sentence of death is thus lawful, it may nevertheless be unlawful to carry out that sentence where there has been long delay in doing so. In particular, where a prisoner is held on death row for longer than 5 years, there will be strong grounds for believing that the delay in execution was such as to constitute inhuman or degrading punishment or other treatment contrary to the Constitution. This case concerns a long delay in carrying out a death sentence. In 1996, Mr. Nervais Boodram was convicted of 2 offences of murder. He was sentenced to death. However, that sentence was not carried out. Some 11 years after his death sentence was first pronounced, Mr. Boodram commenced proceedings in the High Court seeking an order that the sentence be vacated. Section 14 of the Constitution of Trinidad and Tobago provides that any person may apply to the High Court for redress where they consider that there has been a breach of their constitutional rights. Section 14 states that the High Court enjoys original jurisdiction to hear and determine any application for constitutional redress. Upon such an application, the High Court may make such orders as it may consider appropriate. Mr. Boodram sought an order under Section 14 of the Constitution that he be brought before the High Court for resentencing to any lawful penalty other than the death sentence. Mr. Boodram was unsuccessful in the High Court. However, the Court of Appeal unanimously allowed his appeal. The Court of Appeal held that when the High Court is asked to vacate a death sentence under Section 14 of the Constitution, it exercises its original jurisdiction and thus enjoys the discretion to take into account normal sentencing factors. In such circumstances, the High Court may substitute whichever sentence is appropriate. The Court of Appeal considered that it follows that the High Court is not compelled to hand down a life sentence in every case. The Court of Appeal held that it had insufficient information to resentence Mr. Boodram itself. It therefore remitted Mr. Boodram's case to the High Court for it to consider the appropriate sentence. As for the question of costs, the Court of Appeal held that it could not yet be said that Mr. Boodram had been successful in his appeal, as it remained to be seen what sentence would be imposed upon him. The Court of Appeal therefore made no order as to costs. This means that each party bore their own costs. The Attorney General appealed against the Court of Appeal's order, whilst Mr. Boodram cross-appealed on the matter of costs. The Board is unanimous in dismissing the Attorney General's appeal and allowing Mr. Boodram's cross-appeal. The principal issue is whether the High Court, when commuting a sentence of death, may lawfully impose a sentence other than life imprisonment. The law of Trinidad and Tobago provides that every murderer shall be sentenced to death. However, where that sentence must be vacated because of the delay in carrying it out, Section 14 of the Constitution gives the High Court the power to impose such substitute sentence as may be appropriate in all the circumstances of the case. In the appeal before the Board, the Attorney General submitted that, on such applications, the High Court has the power to grant constitutional redress, but has no power to undertake a resentencing exercise. In the Board's view, this argument is semantic quibbling. The remedy for the constitutional wrong in cases such as these is that the High Court vacates the death penalty and substitutes an appropriate sentence. The crime of murder is always very serious, but some murders are even more serious than others. Often, the appropriate substitute sentence will therefore be life imprisonment. However, the High Court is not restricted to imposing such a sentence. That conclusion follows from the wording of Section 14(2) of the Constitution, which gives the High Court the power to make such orders as it considers appropriate. The Board sees no justification for overriding the clear words of that provision. Indeed, to require the High Court to impose a life sentence in every case is impossible to reconcile with the wording of Section 14(2), which requires the High Court to make such order as it may consider appropriate. Furthermore, the Board considers that the Court of Appeal was plainly correct to rule that it lacked the necessary information to resentence Mr. Boodram itself. The Court of Appeal was thus right to remit the matter to the High Court. As to the matter of costs, In Trinidad and Tobago, the general rule is that the unsuccessful party will be ordered to pay the successful party's costs. In his appeal before the Court of Appeal, Mr. Boodram was wholly successful. The Board is of the view that there was no good or sufficient reason for the Court of Appeal to depart from the normal practice of ordering the unsuccessful party to pay the costs of the successful party. Moreover, any rule precluding individuals from recovering their costs, despite having succeeded on an important point of principle, would tend to have a chilling effect on public law challenges to unlawful action by the state. Mr. Boodram should therefore have been awarded his costs in the High Court and the Court of Appeal. The Attorney General must also pay Mr. Boodram's costs of appearing before the Board. This case will therefore be remitted to the High Court in Trinidad and Tobago for it to consider what substitute sentence is appropriate for Mr. Boodram in light of all the circumstances of the case. As to Mr. Boodram's costs before the High Court, the Court of Appeal, and before the Board, they will be paid by the Attorney General.
The Board will not adjourn.